So this is a really big issue from an administrative perspective and also an acknowledgement perspective. You, under no circumstances, are to record it as family and domestic violence leave on someone's payslip. So married with that is there are extenuating requirements or extensive requirements to maintain confidentiality. So once you get a disclosure from an employee, that's where I talk about a manager guide or a policy really is necessary, because you can't just go sharing that with everyone. And not that someone necessarily would by purpose, but by default, I don't know how to deal with this. Let me ask, her manager, and then let me ask HR, and then let me ask. If you do that, you're breaching confidentiality. So it's really important that the disclosure happens to one person, and that there really is some lockdown about the information, that where some information is going to be stored about this and what it's going to say. As lawyers, we initially thought there would be an ability to maybe put special leave on your pay slip, so to be able to identify it still as separate but not. But they've come out and said no, it can't. Your pay slip has to look like what it would look like if I was at work this week. So if I was at this work this week, I get ordinary pay or salary or hourly rate plus your overtime, and that's what it has to look like on the pay slip. So anyone who picks up that pay slip, including payroll, have no visibility at all that it's anything other than that. So the effect of that, what that means is the employer has to have some back of house method of tracking this leave and understanding where it is in terms of, where they're at with the 10 days and how much they've taken and what the evidence is. So we're suggesting there needs to be some sort of back of house recording of it, but your payroll system has to integrate with that. So it is proposing at present a little bit difficult, because if you add it to your annual leave balance or your sick leave balance, then that will accrue over. So it does have to be recorded back of house some way that it doesn't accrue over, but that it doesn't identify. So pay slip doesn't identify. You would be able to have a file under their name that is locked down that maybe talks about the accrual. And again, I'd record it there as special leave, but it's not on their pay slip. It's not visible to everyone. It's only visible to, a certain number of people who need access to it, who can track, okay, they've taken 5 days, but guess what? The 12-month clicks over, so we put 5 more back in the bank, so there'd have to be that recording somewhere back of house. So it is really important. I'd be thinking about that now and not when you get your first case, because that's going to be a real issue. And if you breach it, there are significant penalties. These are civil remedy provisions of the Fair Work Act. So what that means is they're a part of the National Employment Standards that apply to everyone. And if you breach them, there are penalties that apply of approximately $80,000 per breach for a corporation. And I think it's 11,000 per person. So they are significant breaches if you do this. And that's where we think we'll see breaches, is mistakenly putting it on their payroll or mistakenly putting it for visibility. So yeah, although I don't think they'll be brought to hand or penalised significantly straight away, because everyone's trying to get used to how to minister these, it's really something you need to turn your mind to. If you can take one thing out of today, it would be that, is find a way to be able to be recording it and storing it that still complies with your obligations.
Yeah, absolutely. Because I guess, because of the way that the domestic violence can occur, it could be that financial impact that the perpetrator is the one receiving the pay slip. So they don't want to be, you don't want to inadvertently alert them to it, that the employee is sort of seeking their own action to try and get away from their situation.
Yeah, that's it. And that sort of applies to about explaining where the employee is, if the employee's not there, all I would be simply saying is they're taking some leave, they're on leave these days. I would not, you obviously cannot say what it is, but these are all the practical applications of these changes that an employer should turn their mind to, because you need to explain it. You can't just have Mary not turn up to work today, but you've got to be very, very careful who you let know what kind of leave is. And to me, I would be locking it down to 2 people, at maximum, hopefully, the HR manager of the division and or a director or otherwise, but really have this locked down and make sure there's no inadvertent disclosure. So right protect, like if you store it in a personnel file, I'd put a right protector over the special leave component that only people who have the password can get to it. All of those things, I think you've really got to go lock down this information, which is so different to any other entitlement an employee would have.